Okay, here we go. We do our legal podcast, our Battleborn legal podcast on a Thursday night. Justin Watkins, Adam Hill, Cofield. We have some police items to hit early, and then we'll get to some entertainment items. All good stuff on tonight's legal podcast. This is an interesting video, and we have some questions about this. I'm not playing this to mock on this woman, but I think there are some questions that come out of this woman who apparently is law enforcement and had some difficulties at a drive-through at a McDonald's.
Did she though?
Asks me what my order was. I repeat my order and my coffee order, and they asked me to pull up because my food's not ready. It's an English muffin meal with a hash brown and coffee. And I mean, I hadn't eaten since probably about, I've been up for a very long time, but I haven't eaten in a while, so I was kind of hungry. And I'm still waiting. And I'm still waiting. And they asked me to pull up. So I pull up forward, and a girl comes out with my coffee, and just the coffee. And she hands it to me, and I have my window down. And that's all she hands me is the coffee. So I told her, I said, don't bother with the food because right now I'm too nervous to take it. It doesn't matter how many hours I've been up. It doesn't matter what I've done for anyone. Right now I'm too nervous to take a meal from McDonald's because I can't see it being made. I don't know what's going on with people nowadays. But please, just give us a break. Please just give us a break. I don't know how much more I can take. I've been in this for 15 years, and I've never, ever had such anxiety about waiting for McDonald's drive-thru food. So just have a heart, and if you see an officer, just tell them thank you. Because I don't hear thank you enough anymore.
All right, so you get the basic gist of it. Again, I don't want to take shots at the woman, but I do have some questions from a community and legal standpoint. Just your general impression here, Justin. She's clearly upset. Things have been going, rough for her. It's a very stressful time for law enforcement. I think the video is incredibly ill-advised, but give me your take on what you just saw.
Yeah, I mean, I guess my take on it is that she when she's saying she's too nervous, she's thinking they're doing something to her food, and that it's just another instance in which the community is attacking police from her perspective. That's what I'm taking from it. I don't know this woman. I don't know anything about her, so I'm just trying to take it at face value. And I don't think it had anything to necessarily do with McDonald's. It was just kind of the straw that broke the camel's back, I guess. And from that perspective, I feel for her. There's a movement going on, and I think that there's a lot of vitriol that's targeted towards police. And there's a whole heck of a lot of police that are doing all the right things, and it's got to be tough for them. I don't know if she's doing all the right things, but let's just give her the benefit of the doubt for the purpose of this discussion. And if she is, she's been doing it for 15 years. She's used to, she started off the video by saying, I called ahead to make sure I was paying, I paid ahead because it sounds like people often pay for her because she's in uniform. And so, she's used to a certain type of level of respect coming from the community for what she does and gratitude, and she's not seeing it. And not only not seeing the gratitude, but maybe some hatred, and it's getting to her. And it's a heck of a tough job, and I'm sure if I was putting myself in harm's way every day for the community, and the community was metaphorically or literally spitting in my face, it would get to me too.
Adam, your reaction, because I know you were a little more critical, and there've been a lot of people out there who've said maybe she needs to be put on the sidelines for a little bit, because that's pretty scary if she's getting that emotional over her food order and she's that nervous. And just like all law enforcement officers, she's got to make life and death decisions. potentially every minute of every day.
Yeah, and I just feel like, not to criticize her, but it seems like she's really being overwhelmed right now. And I don't think that's the kind of people that you want to have, on the front lines of making these life and death decisions. Maybe just a little time off or something. Like, this is literally something that happens to every person every day, right? That goes to a fast food place. Like, hey, pull up, we'll bring your food up. Like, it's not ready yet. It's a very small thing. And she's reading into it a lot more that's not there. And I think it probably has a lot to do with the fake narrative that was out there about the Shake Shack thing. And, she's, probably thrown off by that. It's fine. If you are feeling overwhelmed, I get it. Like, it happens to people. I think most people have been there in life where just like things are just piling up and you can't take it. But I think that's probably not the right time to be out, on patrol. I don't know if that's the right move. And by the way, like, would this, to spin it legally, like if something happened with her in the next couple of days, like, would this come up in a case? If you're like,
Yeah,
you were freaking out, like, you posted this video, you probably shouldn't have, been involved in any kind of interaction right there.
yeah, for sure. I mean, if something happens where her actions are questioned, then sure, they're gonna, of course, you're gonna point to the video and say, this video went viral. You, as the police force, who are supervisors, her bosses, knew or should have known that she was unfit to be out there. I don't know if she's unfit. Like, she did say she was off her shift. She'd been on a long shift, and doing the video is not wise. But she may wake up. And she said she had a couple days coming up off, and she'd been on for several days. She gets into that narrative a little bit. So I don't know that this would trigger me to say, okay, you're off the beat. But it would probably trigger me to, like, you got to have a conversation with somebody before you go back out. Like, tell me what's going on. We got to make sure that you are fit before you go back out there.
And understand that a lot of times, like, McDonald's has very slow service at the drive-thru. I haven't been there in a while, but I feel like that's kind of the case for everyone. They even have those parking spots, like, on the side, because this happens so often. Like, this is not personal.
Yeah, I get the distress there, though. Like, if I've lowered myself to eating McDonald's, like, the only thing I got to look forward to is that sucker's coming out quick. And so, like, if I gotta wait for it, I'm gonna upgrade, right? I'll go to Fatburger and wait. I'll get something a little bit better.
There goes one potential sponsor. Thanks, Justin.
So we have charges in now on the murder of Rayshard Brooks. Adam, you actually said off the air that you have a problem with the way the charges were handed down. I guess not with the shooter, though, right?
Yeah. I guess my question, to be more specific, is I still have an issue. I have a little bit of an issue with the charge against the main cop. I kind of do. But my bigger question is with the other cop, the one that wasn't the shooter. They really threw the book at that guy. Like,
That's right.
They loaded up on the charges.
How so? What are the charges?
I only know that he's facing 20 years. I'm not sure exactly. Justin might know better what the actual charges are.
The bulk of the charges actually had to do with violation of oath of office, and so they weren't your normal criminal charges. They were specifically criminal in regards to the oath that a police officer takes. And so, by and large, I think most of the charges would not have been criminal for anybody else. And maybe that's the right way to do these things, but it's not typical. It's not common that you're going to see a criminal charge basically for violation of the oath of office. And I tend to agree with you. They came down with these charges and had this press conference to prove up why they were charging the non-shooting cop. And it was with still photographs. Like, here's a picture of him kicking, the person who was shot. And I'm like, is that kicking? I don't. Right. It's a still shot. I don't know if that's kicking. Yeah. I don't know what that is. And another one of him, like, standing on the person, and I'm like, that doesn't look like he's standing on him. It looks like he's standing over him, but I don't know. Like, there's got to be better evidence than that. I mean, they were wearing body cam. There's video out there. Like, there's got to be. I mean, they pulled the stills from body cam footage.
Yeah.
So it was just an odd. It was an odd press conference. It was different, man. And you know, I even have, when I first watched the video the first time, and I haven't seen body cam, but when I watched the video that everybody's seen gone viral, I was like, man, they're not going to charge this guy, right? I mean, he pulled a taser from the police officer. Yes, he ran, but everybody agrees he like then turned back and pointed the taser towards the police officers. And I'm really surprised to see murder charges come down on that.
All right, I have a couple questions on this. The first one is about the charges of the officer that didn't shoot. It seems to me, we just said, like, it seems like a lot of charges against him. It seemed like they overcharged. And my thought was they did that to force him to cooperate as a witness. Like, is that allowable? Like, or is there an ethical violation? Or
bro, man, this is what happened. That's the thing. Like, if everybody is up at that, that's my big takeaway when I watch that whole press conference, right? I'm like, oh, I don't know about that charge, and I don't know about this charge. Welcome to the criminal justice system, man. I mean, if you think that those charges are thin with the evidence, go sit in on a criminal trial. Go sit in on what they charge people with and the crimes that they put together based on the, you know, evidence that's out there. It ain't CSI, bro, man. It is thin stuff. Talk to a criminal defense attorney and talk to them about some of their cases and one of the ones that they're defending, even like serious ones like murder cases. Okay, what do they got on them? You know, well, he's kind of a junkie and he was in and around the scene, so they picked him up. You know, that's very common. And so I think what you're seeing there is very common in the criminal context, which is anything that you could potentially charge so that you could plead down or make a deal for a lesser included charge, right? That's the goal. And if you undercharge to start, you've lost your bargaining power. That's the thought process anyway.
So part of the press conference was, this is a very semantic thing, but I like to get into these things. Part of the press conference was the district attorney says that the other officer, the second officer in the case, the not shooter, has agreed to become a state's witness. His defense attorney is like, whoa. He agreed to cooperate. He didn't agree anything about a state's witness. Is that even a real thing? Or like, all you are is testifying to what you saw, right? So you're not like you're not an employee. You're not a state's witness. Like, you're just going to be called by the state, right?
Yeah, it's funny nomenclature. I mean, it is a term of art in the world to say, hey, state's witness, and that would mean typically a witness favorable to the state. But technically speaking, what does it mean? It means that it's a witness that the state's going to call. Does that mean that witness is going to be favorable? Not necessarily. They may very well call him with the full understanding that he won't cooperate in order to send a message to the jury. Sometimes in a trial, rather than start off with my client who everybody expects to see, or my expert who everybody expects to see, I'll start with the other party. I'll call them right on the stand, and I know they're going to be adversarial with me, and I want that to start off so that I can show, like, if I think that they're being unreasonably adversarial, then I feel like it proves up my case. That I get the jury to not like that witness right off the bat. So later, when they come into the case and are called by the opposing party, the jury's already like, forget this guy. This guy, you know, he's got an agenda. We're not even going to listen to what he says, or we've already heard it, right? But when you are questioning an adverse witness in your case in chief, it's the time where the rules are different. So when I'm questioning my client, or when the state's questioning somebody that's favorable to them, they're not allowed to ask leading questions. You can't say, isn't it true that blah, blah, blah. You can't ask those yes and no questions. You have to ask open-ended questions where they give their testimony. But when you call a witness on your case that you believe to be adversarial, you ask the judge for permission. Can I treat this witness like an adversarial witness? Judge says yes. That means, boom, I get to ask leading questions. I get to send them down this road of yes and no's to get out the testimony I want. and it's very, very powerful. I you know, I'm no, you know, my theories on this are not unique. A lot of people start off trials that way, to corner witnesses into testimony that they can't go back on, they can't correct.
The last thing I had, I mean, I think we could do the shooter for like 3 hours and break down that case. But I am not an expert in tasers and weapons and those sorts of things. I have no idea. I just know what I read. First of all, I would consider a taser a deadly weapon, right? Because if you get tased, they can take your gun and then shoot you with it. So I feel like it should be considered a deadly weapon. But that's not even what I'm asking about. Like, from what I read about it, and again, I don't know this for sure, that the tasers are single fire weapons.
Okay.
So if he tased them right away, he can't, like, because the suspect tased right away and then ran. So
Yeah.
the officer should have to know, right, that he couldn't fire it again. But then the bigger thing would be if the range is 15 feet. Like, does that play into consideration? If the officer knows, hey, it's only 15 feet, he's already running away from me, he's already out of range of the taser, is that no longer considered an actual weapon against them because they're out of the range of the taser?
Super good questions here, right? Because I would agree with you. I think that tasers can be categorized as a deadly weapon, or maybe they should, because we know that people have died from being tased. But the police would have a hard time taking that stance because they consider it a non-deadly use of force, right? So in all of their protocol, it's in the you know, non-deadly force for use. So
Right. Hold on, just to say that. So, but what I mean, I think it's the second layer of, if I have a gun and he tases me, now he can take my gun and shoot me. Like, does that chain? Is that chain relevant to the circumstances?
Sure, right. Like, all that comes into play, but I think what you've heard the officer say through his attorney and statements is he was unaware that that was the taser. He didn't know that he taser, that he thought he had the gun, and that he came and pointed over his shoulder. And so he, from his perspective, it could be a gun, it was a gun, and he fired. So to go down the road of all the other questions, I think that their position sort of eliminates that whole part and makes the case easier from a defense standpoint. But let's assume he knew it was a taser, and all those other things are true. He knew it was a taser, he knew it had been fired, and he was more than the X amount of feet away when he turned and looked. You know, then is he justified in using deadly force? It gets you a lot closer to that line for sure. And ultimately, what's the answer? Whatever the jury thinks is appropriate, right? I'm just gonna tell you, man, like, my first instinct when I watched that video was like, probably justified. You know, like, you're in a scuffle, he's grabbing at you, he grabs something, he starts firing and running, and then goes over the shoulder. Man, and I guess we're seeing some comments that tasers could be shot more than once. I don't know that. I think there's a difference between like tasers and the stun guns that shoot the projectile that sticks in. I think that one, I don't know how many shots that are on that. I thought it was one, but I'm no expert. I don't do criminal law, but the justified self-defense by use of deadly force is going to be the question of that case. Oh, there you go.
Well, like I said, I set this up as saying I don't know. I'm just asking the question based on, you know, stuff that I saw, and just kind of setting it up that way. But man, I think it's going to be tough, man.
Is this moving too fast?
Rob?
Yeah, is it moving too fast? Rob says, how about the investigating agency not finishing the investigation before the charges?
Doesn't need to happen, right? The district attorney's office chooses whether to charge somebody. The investigating agency does their investigation and turns over that evidence to the district attorney to do what they want with it. If the district attorney believes that they are in possession with sufficient evidence currently to make a charge, they can do it. They don't need permission or completion of any underlying investigation agency. They're two separate, right? Law and order, right? Like that's the whole show, right? Is one's the investigation and one's the courtroom.
All right. I wanted to move on to another leg of the story, and that is the recent attendance issues from police officers in Atlanta. They've had shortages for the last couple of days. First of all, what do you think about how the police are going about this? Because it's not officially a sit out. It appears more to be a sick out, and I guess that would protect them legally, right? How would you go after them if they're like, hey, I'm sick, sorry?
Yeah, if you can find a coordinated effort, right? If you can get in, say, text messages, email chains where everybody coordinates to be out sick, then they're going to have a hard time in any grievance for being fired or disciplined. And that's ultimately, I mean, they're collectively, well, I don't know if Atlanta police are collectively bargained, right? State employees in the state of Nevada are not allowed to collectively bargain, although that, we're not allowed to collectively bargain up until this last legislative session. So, I don't know what the grievance process is. I don't know if they have collective bargaining rights in Atlanta. My guess is Georgia being predominantly red state, that I would guess that they do not have collective bargaining rights. But there's probably statutes and ordinances in place in regards to discipline. And so if you're saying, you're alleging you're defrauding the police force by saying you're sick when you're not, and it's coordinated effort and you're going to be fired, that kind of evidence would come into play. Ultimately, if it's a dangerous game they're playing, if you now have a district attorney who's charging based on violations of oath of office, because that would seem to be a violation of the oath of office.
Yeah, how do communities in general, what kind of recourse do we have if, law enforcement across the country decides to walk out? Obviously that's been the extreme response to an extreme theory, completely defund the police, which I don't think most people are asking for, completely defunding them. But how do we protect ourselves in these communities from police just walking off the job?
Yeah, it's like any union negotiation, right? That's their ultimate bargaining power is we are more qualified than the general public. That's why we're unionized. That's what gives us power. And if we strike or we leave or, like in the state of Nevada, the police do not have the right to strike legally. But that's legalese, right? Practically, they can do an effective strike. And so same with teachers, effectively they can do a strike without calling it a strike. That's the risk that you take in having that. And ultimately what ends up happening, sometimes in the most extreme measures, they all get fired and they build from the ground up again. Normally, just from a public safety standpoint, that would seem like a really bad idea for your community police. But at the same time, man, I look at some of the qualifications and backgrounds of some of the some of the police officers that were involved in the Floyd case, and it's like, man, it's not like they were the creme de la creme.
No, and I had sent you earlier, and this is an extreme case. Because a lot of this does come down to what's happening right now with unions, with police unions and law enforcement unions. But I did send you the story earlier, and I remember this as a kid back in 1981 when air traffic controllers were having their issues in terms of pay. The president just fired nearly 12,000 of them.
Mm-hmm. And this
does that have any relation to what's going on now? If law enforcement agencies just decide to walk off the job?
Of course, right? Like this is the nuclear option, and it's often remembered because it was such an extreme measure, and the fact that it really nothing like that has ever happened since shows you how drastic of a measure that is. I mean, it's a 40-year-old measure, but people love to cite it as what the tough guy should do in these. I'll call it negotiations or strikes. And, the question remains, do you have people who are qualified to take those spots without a serious interruption to the public health and safety? From an air traffic controller standpoint, as the president, he's the chief executive officer of the United States and the military. He's the chief military officer, and you're going to have a whole bunch of people in the military who are qualified to do air traffic control. They know what they're doing, and so he would have sort of access to people right away to ensure that there's no disruption while others get trained. Police, could you do the same thing? Maybe you could, but police isn't federal, right? Well, there are federal officers of U.S. Marshals, but generally speaking, on the local level, it's policed by local jurisdiction, and that's how you police state crimes. So, so the atheist on there, mod atheist, saying do the same thing, get the military over. It would take a hell of a lot of cooperation on a state and federal level to make something like that happen. Because the only access that a state has to military is going to be the National Guard. And so that's going to come from a governor. But what happens if you're the mayor of the city and you're dealing with the whole police force effectively striking? There is no such thing as the city military. You would need coordination with your governor, coordination with the president to make something like that work. I'm not saying it's impossible. I'm just saying it's a much more coordinated effort.
So let's go in a completely different direction. Interesting statement today from the CEO of AMC Theaters as we start to grapple with next level mask questions here in Las Vegas, as maybe casinos or at least gaming, or the state is going to require people to start wearing masks at casinos at the table games. But yeah, the AMC Theater CEO, Adam Aaron, says their cinemas won't require masks upon reopening because they didn't, quote, want to be drawn into a political controversy. I think there's an interesting, policy decision here, but also the public statement I find fascinating.
Yeah, I mean, I see what he's saying. It has become a political controversy, but it also it's rooted in science, right? I mean, ideally, your policy would be this. If anybody's exhibiting any sort of symptoms or has been in contact with anybody, you should wear a mask at all times, right? When you're out in the public. But the public's not doing that, right? Ideally, if you're showing symptoms, you're not even supposed to go outside, right? You shouldn't even go out and be around the public, but that's not happening either. So there's a lot more evidence out there now that says that the spread is through people when they become symptomatic, and that there's very little evidence that there is that the spread is caused by people prior to symptoms showing or when they have it and are completely asymptomatic. So if everybody, I think you got to fall back to, I support for Vegas too. I support, hey man, masks for everybody. But from a business standpoint, they're saying like, we're going to lose half the customers because it has become a political hot potato where people are saying, you got maskers and anti-maskers. And if you ask to enforce masks, you're going to lose a whole bunch of people. They're not going to come.
Adam, you got some follow-ups?
I mean, I think one of the things that jumped out at me is there any legal recourse for like mask intimidation? And I'll say, like, I was out the other night. I think I told this story. I didn't want to go out last week, but there were some people in town that I said I would say hi to. I was like, all right, let me stop by. I went in, I had a mask on, I stayed way away from everybody. There was one guy who I've known a long time who was like, he was drunk, obviously, but he was angry, and he like stood over me and like, you feel really good about yourself wearing that mask, don't you? And like right in my face, like pushing me backwards. I was like, bro, like what is the problem here? First of all, like get away. But like, is there any like an intimidation type thing like that? Is that a legal thing? And like entering somebody's space that clearly doesn't want you to enter their space, like, is that an issue too?
I think so. I mean, I think that sort of same interaction 6 months ago, you put that in front of a jury on a civil claim for like assault, because that's what it would be, is like, hey man, I felt like he was threatening my well-being, and I was in immediate fear of bodily harm. That's assault. a jury would say, hey man, I don't see it. So he's sort of in your face, like, no. But I think today's jury, like if this got in front of a jury today, I think you would have a whole bunch of people who are ultra sympathetic to that situation and say, like, yeah, man, you had the right to use physical force. And the fact that you showed restraint, you should be commended for. And this person, that's assault, like for sure. And yeah, I know what you're saying. Like, I've got loved ones who are in the middle of chemotherapy. I wear a mask everywhere I go. And, I've only had one instance in which, somebody was like, those masks don't work. And I was kind of like, hey, man, when you got somebody going through chemotherapy, if it's 0.01% chance that it increases the likelihood that I'm not going to catch something, then I'll do it. I'll do anything at that point.
Yeah.
And
What the person say back?
he kind of, what do you say to that? He was kind of like, oh yeah, it's kind of
yeah. Mind your own business.
I mean, what do you say? Like, no, you're stupid, like. So yeah, I know, like I get the look sometimes because I wear it everywhere, right? And like soon as I leave my car, it's on. As soon as I leave my office, as soon as I leave my house, or except for when I'm driving in the car and it's just me, I have the mask on. And yeah, I get some looks every now and then, but who cares, man? Like if you got vulnerable people in and around you, I'm going to do everything. If they told me wearing a stupid hat was going to reduce the risk, I'd probably do that too. Even if it doesn't make sense, I'm willing to do it all right now.
I think the answer to this question is kind of obvious, so I'll let you answer it. The woman coughing on people in the bagel shop clearly would be considered some sort of assault. But would the counter be like, hey, if you're really trying to be careful, you wouldn't be out. You wouldn't be out at all.
If you're right, but that's
like legally, if somebody made the claim in court and said, hey, that's assault, you're coming after me like that's assault, and the defense would be, dude, don't go out then. If you're really that scared, why you wouldn't be out?
Yeah, I mean, you could go to the extreme with that kind of thinking, though, on a slippery slope and say Nevada's an open carry state, and you go outside and somebody points a gun at your face, and you go, whoa, like that's not cool, that's assault. And they go, well, dude, it's an open carry state. If you're not down to have guns pointed in your face, then don't go out, right? There were protocol in place that said everybody has to wear a mask. It was in a bagel shop, which is, it's food service, going to be considered an essential service, and everybody else was abiding by the protocol, and this person was offended that they were being asked. But then to take the extra step to like go get in the person's face and cough, that is absolutely with the intent of creating fear in that person that they're going to be hurt as a result of it through contraction of the virus or otherwise. So like, absolutely, she should be charged. I don't know if she has been. I'd be surprised if she hasn't, because just the Twitter like identified her real quick, man. They were on it. And I thought you were gonna pull up the video of her.
No.
It was something else, man.
I don't have it. How about this story? I think this is one you wanted to hit on tonight. MLB tells union it won't start season until players waive right to grievance hearing.
Yeah, this is stupid. Because one of your major grievances, the grievance would be that sort of the ultimate trump card is bad faith negotiations, right? You're not participating in good faith efforts to negotiate. That's your obligation to your union. And when you say we will do X, but it requires you to waive any claims against us for bad faith, you are, by saying that, committing bad faith. So like it's ill-advised at best to be public about that, because that's exhibit one. Like, how could this be good faith negotiation if they're requiring us to waive our bad faith claims? Like, it's not. You can't do it. And the players are right by absolutely just out of hand saying, no way, we're never going to do that. And baseball is the strongest union out there, man, and they have never waived that, and good for them.
Well, if they came to an agreement, though, what you can still file a grievance about the agreement down the road.
Yes, absolutely, right? So I'll bring it to like everyday life for everybody else, and frankly, more in line with what I do on a daily basis. If you make a claim against your own insurance company, either your house was robbed or you were in a car accident, the other person doesn't have insurance, but you have uninsured motorist coverage, and you make a claim against your own insurance company, your own insurance company has two duties. They have the duty to do what's best for you as their insured, and they have a duty to look out for their best interests as well. And to the extent that they can make those two duties align, then they're in business. This is got to be the law in all 50 states, but when you can bring a bad faith claim against your insurance company for mistreating you through the claims process. And so this happens all the time. We do this. We bring a claim, they commit some sort of bad faith, right? Like say, oh, well, we don't think you're actually hurt, but they don't have any medical opinion to support that. They've never had a doctor look at the medical records, what have you. They say, we don't believe you, you're a liar. And they try to dig up some dirt just to avoid paying the claim. Eventually, we go through the process, we get it done, right? They go, okay, it's a valid claim, and they pay it, right? They pay it, we don't release any bad faith claim. If they ask us to release it, it's just another piece of evidence. And then as soon as we accept that money, we sue them the next day for their bad faith claim participation. It's a separate and distinct claim. It has to do with the handling of the claim. Here, the bad faith grievance would have to do with their handling of the negotiation, irrespective of the ultimate result. The fact that they work it out later through the bad faith does not eliminate the bad faith.
All right, totally different direction. Unless you had a follow-up, Adam.
No, we're good.
You're all good.
Yeah.
This is let's talk a little sexual assault and rape. Sounds real positive, right?
Yes.
And we go to the entertainment industry. We'll get to Danny Masterson here in just a minute, but this one's interesting, and especially in the headline. I'm not even sure if this headline is accurate, but because we're not exactly on the most official website at vladtv.com, but judge rules the game's sexual assault accuser can collect rappers' royalties. What's going on here?
Yeah, so first thing I want to say about this, and you've already noted, like, what kind of website we're dealing with. I don't know Vlad TV, but there has been a woman alleged that the game sexually assaulted her. The case went to a jury, and the jury agreed with the accuser and awarded a judgment, 7-something million. You as a journalist from that point forward are free and legally correct in removing the accuser label and removing the allegations, and you can say the game's sexual assault victim. It is established as a matter of law that it is a fact that he sexually assaulted her. Okay, it's no longer an allegation; it's an established fact, legally speaking. And so I always hate when somebody wins their case, but they're still in the journalistic or in the public realm considered like accusations. Nope, it's fact. So what happened here is she got a judgment, and collecting on a judgment is very difficult, even against rich people. They love to hide their assets, as we saw in Tiger King, right? Like he was really bad at it, but it took years and years and years for them to keep chasing his assets because he kept transferring title, moving things around. That's what can happen here. One of the best ways to collect on assets is to go to a payor. So you go to the employer, you go to somebody who has an obligation to pay that person on an ongoing basis. So what they did is they went to the recording company and said, hey, you pay regular royalties to the game for his music. That we want to intercept that transaction, and you have to pay us until this judgment's satisfied. Totally cool, totally legal, and a great legal move. To bring it to sort of everyday situations, the most common form of collection is against an employer and the paycheck, right? Now there's lots of restrictions on what you can and can't do. You can't you can't garnish more than 25% of the wages in the state of Nevada. There's a lot of restrictions to make sure that people can still make a living and take home some money, but those are not going to apply to royalties. I'm sure that attachment is for 100% of the royalties being paid until that judgment is satisfied at $7 million. And so, good on her, man. She's the victim of sexual assault. She's got a judgment, and she's got some good attorneys who found a way to collect.
There are some payments that can't be garnished, right? I mean, I think you were kind of referring to it, but isn't like I thought I remembered it with the OJ collection, and like they couldn't touch his pension.
Right. So pensions are not collectible. Wages to 75% are protected. Most primary residents are protected in most states under homestead. If you file a homestead, Nevada's got a very friendly homestead provision, which is in most states you have to homestead your home. You have to file a homestead early on after you've owned the home before the legal action has started that is attempting to collect on you. In Nevada, you don't have to do that. So you could go through the whole process, and the day they get the judgment and they send notice to the recorder's office to lien the property, you can record a homestead and you're protected. As a primary residence. If it's rental property, all bets are off. You can go get that. But yeah, there's lots of restrictions. If you've ever, maybe there's some people on here who have filed like a small claims case and trying to collect on a couple $100 judgment. There is, when you do the writ to the court to attach property, personal property, cash, or real property, the list of exceptions is voluminous, and you have to check that none of these exceptions apply.
Brady had a question. What's the thought process behind not allowing pensions to be collectible?
Well, I mean, that's always been the rule. So that's a good question. My thought process would be typically if somebody's collecting on pensions, that's their only source of income, and we protect the primary source of income for individuals. But that's not fully encompassing the rule, because you could still actively be working and they can't collect against your pension into the future either. So I think the thought process is probably not necessarily grounded in good policy essentially, but it's in lawmaking, what can get done. And you got all these different unions with a lot of political power saying, dude, you cannot attack our pensions. And then you got a lot of people on Wall Street with 401ks that they handle saying, you can't attack these things, and that's how it goes. And there is sort of some legal hurdles there too, because a lot of times in a pension, you will have primary beneficiaries for when you pass. And in theory, they have a legal right that's superior to any person that would be attempting to collect on a debt in a similar way, but not exactly as to why people put things in trusts. The legal essence of a trust is I'm divesting myself of the ownership interest in all of my property and giving it to the trust. The trust allows me to use that property for my lifetime, but it's actually owned in title by all my beneficiaries, but they just don't get to use it until I die. So it's a lot of legal gymnastics to get there, but I think that's generally probably why it happens.
Ryan Carl Hill had a question from earlier. Civil case ruling should not be considered an established fact. I think Pappy Hogan came over the top and said the civil case ruling is the fact.
That's right. The jury is literally called a finder of fact. So when they establish a fact as true, you are legally protected in saying that is fact. That's what. We all acknowledge that it's very likely that a lot of things that a civil jury determines to be fact is not exactly how it happened. I'm talking about your legal protections as a journalist and saying this is fact. You no longer have to say accuser. You no longer have to say allegations. These are established facts.
Brady,
that goes if there's a plea that still stands.
Well, it depends on the plea, right?
Right.
So there's Alford pleas, which are saying that's not true. but I'm gonna go ahead and accept the punishment because I want to be out. There's no locatendo pleas, which is saying I'm not even addressing the facts, but I'm accepting the punishment. So, but generally speaking, the plea agreement will establish facts, right? That's what you're pleading to, is these things are true, or in a NOLO, these things I am not disputing.
All right. Brady had a couple of follow-ups. One, he says, so we can call OJ a murderer because the civil court found him guilty.
Correct.
Interesting. The Chris D'Elia case, which I don't think we ran by you, but Adam, you want to run by Justin real quick? Because Brady was saying, can you bring up the D'Elia case? Is there not anything illegal he was alleged to be doing?
Yeah. I mean, technically, I think I asked Justin if there was a law. I can't even remember if it's on the air or off the air anymore. But if there's a law against grooming, and grooming would be like starting to communicate with what he's accused of basically is DMing a lot of fans that are underage females, and basically now there is some accusations that he actually was engaging in relationships with them, but others around Hollywood have said what he did was start these communications so that when they turned 18, he would be able to then start, seeing them or dating, whatever you want to say he's doing, engaging in relations with them. So I think a lot of people have been shocked. A lot of people that I've talked to have been shocked that there's not a law against it, a law against basically like developing a farm team, waiting for them to get to the big leagues. I don't know. I feel like there probably should be some sort of law, but it seems like there might not be.
Yeah, there's not. I can't speak for every state. There's a movement, and the law is behind the times and trying to catch up in regards to, I'll just say, underage sex as a whole, right? I mean, let's start with the absurdity that existed less than 40 years ago with abducted in plain sight, right? Where like parents can consent to a child marrying a full-on adult, in most states, to there being a 2-year statute of limitations on sexual assault of a minor, right? Like that, we now know that the damage done to minors that are exposed to sexual assault has a reaction mentally that they are unwilling or unable to address it in an adult fashion just because they turn 18. And so a lot of states, Nevada is one of them, have extended statute of limitations there to be 20 years from the time you become an adult. So give you the opportunity to heal, process without having to force you through litigation, which could, if you do it without the proper counseling, do more damage than good. So that's a little backstory on the movement that's happening. That law that I just cited from Nevada just passed in the 2017 legislature. So we're talking about recent laws coming onto the books, and now this issue is truly bipartisan. When you go up into the legislature in any state, these child pornography, child abduction, child sexual assault laws that are coming on the books may come from Republicans, may come from Democrats. It is a bipartisan issue to address this. Do I think that a clever district attorney could find a criminal law that's been violated? Probably. I'm sure there's some law on the books about like indecent communications with a minor, something like that you could find. But are you going to find a law on the book in most states that say, hey, you're not allowed to talk in a sexual manner or begin the mental manipulation of a child in the hopes that when they become legal, that you have so damaged them mentally that you can take advantage of them? I'm going to say that no, you won't find that. But if somebody came to me, what would I try to do? I would actually use the elder abuse and neglect statute, which is usually used for the elderly, but does not say elderly. It's in the title, elder abuse and neglect, but it says vulnerable people as a result of age that are taken advantage of financially or physically. And so I would try to use those lines of statutes to go after these people. And who knows if you'd be successful, because you'd be trailblazing, right? You'd be creating law. But it would be a worthy endeavor.
Let's get to the other big entertainer case, and that is the rape charges that just came down for Danny Masterson, which actually go back to the incidents were 2001 and 2003, and I guess this has taken forever to levy these charges. To your knowledge, why did it take so long? Who was protecting him? How was he protected?
Weird one, man. I don't have enough information to say what the hell's going on here. My first thought is when the allegations came in 2003, 2004, it sounds like they were pertaining to something that happened in 2001. And like we just talked about, statute of limitations were not as favorable back then as they are today. And so it may very well be that the prosecutor was like, I can't do anything here. The statute of limitations is up. But they haven't said that. Nobody from the district attorney's office has said that. So I will note right now that California no longer has a statute of limitations for sexual assault. So you could bring the case 100 years from now if you're still alive and pursue it. So there have been drastic movements in the law, and especially the state of California, but in most states in regards to the statute of limitations. So, but now there are sources that are cited in these articles that say from within the district attorney's office that they believe there is substantial amount of evidence, audio recordings, videos, emails, text messages that establish these facts, and they are frustrated that this is being quote unquote slow played. I don't know, man. By all accounts, everything I can find on LA County prosecutor, he's well respected. He's considered meticulous. I don't know. I hate second guessing the legal strategies for cases that I have no direct knowledge of. I don't like giving opinions on cases that are in trial if I'm not watching the trial. It's really easy to throw on a 3-second soundbite for a trial that takes 3 months, but when you're sitting in the courtroom every day for 3 months, the whole dynamic's different. And so I don't know what's happening here, but it's certainly troubling. And I think the only reason that there hasn't been a bigger outcry is because of the stellar reputation of the district attorney. To answer Brady's questions in the comments about can statute of limitations be retroactively applied, no, they cannot. If the statute of limitations has already expired. So if the act is within the statute of limitations period, it can be extended, but you would lose, I believe you would lose on constitutional grounds if the statute of limitations has already expired and you re-upped it. But I will say this, hasn't stopped California from trying. Their law reads very liberally in that regard. And I'm licensed to practice in California, but I'm not an expert on the California Constitution. And if the California Constitution doesn't have a restriction for retroactive laws, you might be in trouble as the perp there. But you still have the federal Constitution that's going to apply. So if there's criminal charges coming down, I still think the United States Constitution is going to prevent retroactivity. But civil retroactivity is a different question because it's not taking away your liberty.
So in regards to this question from a Pro Martini Maker, one of our regular questioners here, commenters, Church of Scientology is, Masterson is a member and was a very prominent member of this. This actually came to light on the Leah Remini documentary about Scientology, where one of the former members said that this happened to her and she reported it to the church, and they absolutely tormented her about it and wouldn't let her come out, and then covered up these other allegations as well. So would they have any exposure to charges or civil, I guess, suit would be?
Yeah, especially in this case, because as I understand it, when the first allegations came out, they provided the district attorney's office with 50 affidavits that said that what the accuser was saying was false. And so if that was a coordinated effort to discredit the accuser based on false information, they've got a lot of problems, right? Because an affidavit exposes you to perjury. So you'd have criminal perjury charges, a number one. But from a civil standpoint, on the part of the accuser, you would have a civil conspiracy to take away the rights of your civil remedies. And so, yeah, absolutely, they'd be right in the middle of the crosshairs on it.
A weird question, but I just saw his statement from a couple years ago, and then he reiterated the statement again this week. But he basically said, the accusers are lying. Law enforcement has already cleared me of this, which clearly isn't the case. I mean, it's a very minor part of this, but would that be slandering an accuser if you said, I've already been cleared of these charges?
No, I don't think so.
The case is still open?
No, I don't think saying the clearing is slander. I think that's an open interpretation as to what he means by clearing. Saying, hey, they investigated and they never came after me, man. I've been cleared. Right? He didn't say the investigation's closed. I think if you're looking for a defamation claim, the claim would be they're lying, right? That's the claim. That's a statement of fact that says what they're saying is false, and for the specific purpose of harming their credibility.
Last one, we wrap on this. I know you wanted to hit this one, Justin, and that is up at Reno, which I pointed out, I think it was yesterday on the air. I think it's really interesting that Reno has not embraced Colin Kaepernick and kind of shoot him away, considering all he's done, and now it's more comfy to embrace Colin Kaepernick. Says here, growing grassroots campaign aimed to erect Kaepernick statue on Reno campus. So what's the deal here?
You're actually surprised that Reno wasn't embracing Kaepernick? Have you ever been to Reno?
Yes. Believe me, my delivery was dripping with sarcasm.
Yeah, I'll just tell you, man. I mean, from an overall standpoint, my experience in Carson City exposed me to some roots of the North that are from a racial justice and equity standpoint embarrassing. I tell this story that there is this park that's a couple blocks from the Supreme Court of Nevada, from the state capitol and the state legislative building, and it's literally blocks. You walk it, and they have. When we were up there, I moved my whole family up when I served in the legislature for that semester of school. My kids went to school there, which was a whole nother. We can have an hour podcast about that. But, they had their yearly county fair or state fair in this park, and there was a specific set of booths for Confederate flags and Confederate shirts and Confederate everything, and nobody said a thing. And I have some younger women who work at my office. One of them is a dreamer, and so we were talking about the DACA ruling today, and she asked me about that, like, oh, what was it like up in Nevada? Is it, are they pretty understanding of racial diversity? And I told her, I got to see Carson City when there was not legislators around there. They go back to Vegas for the weekend. We stayed there, and Carson City outside of legislative session for the other 20 months out of the year is a very different place than for the 4 months that legislative session's in place. And I told her that this, I had I served with a number of black legislators. The most black legislators that had ever been in the Nevada state legislature at one given time was the session I was there. Maybe 2019 beat it. I'm not sure about that. Anyway, a couple of them I was very close friends with, and it was understood that when we left the legislative building to go to a bar or a restaurant or anything, when the night ended, you did not let a black legislator walk alone on the streets of Carson City at night. Like you went in pairs, you went with them. So, I mean, I have just direct experience of that, and I'm glad to see that there's a movement to recognize what Colin Kaepernick has contributed to this conversation, even if you disagree with it. I mean, as a university, I think you'd really want to embrace that. But the other aspect of this that I wanted to talk about was that the NFL has made all of this movement towards, we understand that Black Lives Matter, but they haven't said Kaepernick's name in that regard, right? We didn't do right. We didn't let people speak, but they haven't said Kaepernick's name. And you asked me on the air the other day, Steve, like, why aren't they using Kaepernick's name? Is there any legal reason why they're not using Kaepernick's name? And I on the air I was like, nah, I don't think so. I think they're just being ultra safe. But as I thought about it over the next couple of days, there may be. And in that settlement between Kaepernick and the NFL and his grievance and the payout they made, I bet there is a provision that says that the NFL can no longer capitalize on his name and likeness for profit. And if they were to use his name as a way to show credibility or outreach to the Black Lives Matter movement, he may have a claim saying, no, you're using my name and likeness in order to establish goodwill, and that has a monetary benefit for you, and you're prevented from making money off of me ever again. And I bet that's in the resolution, and it's just an interesting concept to think about, that if it's true that he would have to consent to allow the NFL to use his experience there as a way to establish credibility or make good on past deeds.
My first thing, Justin, is you told that story about serving in the legislature and how your black colleagues were treated. You served in what, 1964?
Yeah, 2017, right?
It's unbelievable. But I mean, believable, but unbelievable. I guess when you mentioned that the claim that they could make of capital or using his name and likeness to profit off of it, I mean, wouldn't they be able to just say it and not? They'd be like, hey, this is not a profit situation. This is just an apology, or are they just trying to be ultra careful and to say just don't use his name at all?
If they did that and I'm cap fraternities, I'm all over it, right? You're using my client's name as a basis for, I would argue, you're using my client's goodwill as a basis to try to establish an olive branch and a connection to the Black Lives Matter movement, because the Black Lives Matter movement and how you treated that movement in the past is now harming you financially. So you're not doing it because you believe it, because if you believed it, you would have done it before. You're doing it because it affects your bottom line, and you're using my client's name to limit the damage to your bottom line. There's a financial component to it. And so I would argue you are absolutely there. We can calculate this, and you're going to have to pay the damages. Good question in the chat about whether or not they could sell cap jerseys. I don't know. I don't even know that the agreement says that. I'm guessing that it limits the way in which they can use Kaepernick's name. It may not limit jerseys. I don't know. And I guess go on NFL.com, see if you can find a cap jersey. Probably not.
Just to close out on the reference I was talking about earlier, excuse me, on what I was saying on air, I thought this was interesting. So I did say on air early Wednesday show, hey, I think Reno's kind of turned its back on Kaepernick, kind of pushed him away. And a Reno grad said Kaepernick's image is all over campus, so I'm not sure why you think they've turned their back on him. So was I inaccurate on that, or if we go back to
No, they have too. There was a display. University of Nevada, Reno has a display at the Reno Tahoe Airport where they, show, alumni memorabilia and all of that. And they had an image and jersey of Kaepernick, and people complained after he started kneeling, and they pulled it down. So yeah, I'm sure his image is throughout campus because he's one of the, if not the most winning quarterback they probably had at the school, or one of, and certainly the most famous football quarterback to come out of the University of Nevada, Reno, and and so I'm sure his image is on the campus, but is it prominently displayed outside of football context? And have they caved to public pressure when he started kneeling in protest? That the airport is one example that we know of that they in fact did cave. So I agree with you, Steve. I think that they did turn their back on him. They certainly didn't embrace it. That's for damn sure.
Right. All right, guys, great job. We'll have this up on iTunes, and I'll send out a SoundCloud link later on just for the audio, but the video will be available. So look for it if you missed the beginning of it. And we'll be back next week with the legal podcast with Justin at 10:30, and back tomorrow night for another happy hour. Last night's was kind of rowdy, raucous. You missed that one, Justin. We had a new star entrant into the podcast crew, but I appreciate you guys staying up late. Thank you to all the viewers, and thanks to Justin and Adam too.
Thanks, guys.
Thanks, Justin.